Greetings and welcome to our lecture series for Company Law Unit Module brought to you by Simplified LLB Series. My name is Ayub Okayo and today I'll be teaching you our fifth topic of this module, which is on the company directors. Under this topic, we shall cover the duties of directors, various stages of appointment of director, the position of director, and the relationship between the director and the company. So, welcome. Let us now explore this topic together. Now, for every company, there is a statutory requirement under Section 128 of the Companies Act that a private company should always have at least one director, and that one director of a private company may be only a natural person and not a juridical person as the only director of that company. Under the same section 128 all the way to 129 also looks at the public company requirement on having the director. And under this, the public companies are required to have at least two directors, of which one must be a natural person. Now, before we even go to subsequent uh, segments of this topic, it's important for us to understand the duties of director. There are several duties of a director, and I'll highlight one after the other. One, the director has a duty to act within the powers. So the articles of the association of the company lays the structure and the guidelines on how a director should uh, um, uh, govern the company itself. So in every action that they do, the powers they will from the articles of association, and at all times they must act within the parameters of those powers as coded within the articles of association. If they go beyond the powers of articles of association, of course, that will be called as an ultra vires act by those directors. It has its own consequences, both on the company and also individually or severally liable for such ultra vires acts. Directors also have the duty to promote the success of the company, and in this, in every decision that they make, they must ensure that such decision is to benefit the company, is to um, promote the success of that particular company. If a decision is being made that a director knows that is going to jeopardize or rather disadvantage the company itself, then such uh, act will not be allowed or will not be adopted by the members. So they have to always make sure that they carry out their mandate for the sake of the company and for the success of that particular company. It's also a duty of directors to make independent judgment so that in the event of any decision that they're making, it should not be that they have been coerced or they are conflicted in the interest or they are acting through the external pressures and not through their own independent judgment. So the the director is um, has a duty to exercise independent judgment at all times in the event that they are making any decisions for and on behalf of the company. It's also a duty of a director to exercise reasonable care and skill. So, with that, if a director is appointed as a director who is an accountant, then he ought to exercise that reasonable care and skill that comes with that profession. So if he's a director for legal affairs, for example, and is exercising their powers as such a director, then they should always have that reasonable care and skill of a legal person in their own day-to-day management of the company or in the exercise of their duties. The directors are also obligated to avoid conflict of interest. So, in case they are trading with the company, they have to declare the conflict of interest. In case they are doing any business, let's say maybe one of the people who are trading with the company is associated to one director, and director has exercised his powers inappropriately by bringing in maybe a family member, which may conflict the interests of the company and that of family, then the duty of a director will have been violated through that conflict of interest. Also, directors have a duty not to accept gifts, especially from third parties in exercise of their office. So it's not like you will just come and say, maybe I'm the director. If you do maybe ABCD for me, and maybe through that doing, you receive some gifts on behalf, on your own behalf, and for your own benefit and not the company's, then the Company Law Act does not allow a director to use their own office for or to accept benefits from the third parties. So it's also important at this stage for me to mention that companies are to keep the register of all the directors in that particular company, and in case of any changes on their directorship, maybe there have been a replacement or there is maybe a director has been removed from office, then such information or any changes of that nature must be um, uh, registered with the registrar of companies. Now, how are directors appointed? There are various stages of appointment of directors, and I will run through these four major ones. First is the first directors of a company. So directors are appointed at the onset of the company before the registration. I remember looking at this when we were handling the registration of the company. We say there are documents which must be launched at the registrar of companies, and at the same time, there must be also the list of the initial directors and also initial officers who have been appointed to act the moment the company comes into existence. So those first directors are appointed by the promoters of the company. So during the promotion stage, that's when they come up with the director of the company. That's called the first director or the first directors. They can be one person or they can be several of them. But all that, they must launch these names and address and all those that can identify this person with the registrar of companies. We also have subsequent appointment of directors, especially in general meetings. And general meetings, remember that the members of the company or the subscribers um, of that memorandum, they most of the time do appoint or fire a director through the general meeting. So they can replace a director if they are not happy with how the director is running the company. But they can only do that collectively using a collective voice, where they have two choices, either to voice out or to sell their shares. So most of the time when they want to change the directors, they will just vote for the director to be removed, and with the special majority, a director can be removed from office and another one be replaced. And such process of appointment is called subsequent appointment of directors. Thirdly, we also have appointment to fill a specific vacancy when it comes available. So when there is maybe a director who has died, a director dies, or maybe there is a need for additional director to the board of directors, or perhaps at some point after the removal of a director and the office becomes vacant, and also maybe incapacitation or bankruptcy. In any of those cases, also a director may be appointed to fill the vacancy. It's also important for us to understand the fourth way of appointing director, and that's appointment of alternate director. An alternate director is appointed by another director to temporarily represent them in affairs of the company, especially on the board of directors. Then in the event that they are appointed, they must only exercise their powers to the extent where it's permitted by the articles of that company. Now, what are various types of directors? There are several ways we can identify directors, and one of them is the managing director. So the managing director is that topmost person who has been given substantial powers to um, manage the company, and he chairs the company. Most of the time he does has more responsibilities than the rest of the directors. So the managing director is on a top level, and he contains the substantial powers to manage the company. And through that, they normally um, run the company on executive as executive directors, because they have to do the day-to-day running of that particular company. So we also have the executive directors. Of course, managing director can fall under the executive director, but executive directors means those directors that deal with the day-to-day running of the company. They are hands-on, and they must do at least um, the governance or management of the company on day-to-day running of that business. We also have the non-executive directors. They are also directors who sit on the board, but for these ones, they may be on board for specific purpose, but they are not necessarily in charge of any part of day-to-day running of the business. For example, we can have a non-executive director who is an accountant, and for that, he will only provide his expertise in that part of the profession. But on day-to-day running of the business, he may not be taking part. Or they may have a non-executive director who is in charge of risks management or anything related to that. In as much as they have the operation, I mean the office in to operate in such a manner, they most of the time do an oversight on the executive director. So they are the ones who make sure that executive directors are doing things within the law and according to the articles of association of the company. So in case of any deviation, the non-executive directors are the one to do the oversight, to look at the legality of any action being taken by executive directors. We also have the corporate directors, and these ones are mostly directors that are not natural persons. Most of the time, maybe the company or a corporation that is fielding it itself as one of the directors in the board of a company. Let's say in their subsidiary company, they may appoint that holding company as one of the directors, so that such director can also have decision. And of course, it is a decision which is from the holding company. So it is just a company that is representing the whole. I mean, the company itself, the holding company itself, representing it itself as a director in a subsidiary. We also have associate directors, where a company may appoint one or more um, people on the board of directors, and sometimes can be an employee, or it can be um, any group of persons that may require representation within the board. And of course, the powers of associate directors are so much limited, to the extent that they may not have powers to make any important decisions, but to represent the interest of that kind of a group. If it's employees group, then such a director will represent the interest and the needs or um, demands from the employees. Now, as we've already seen, there are directors and there's a company. It's important for us to look at this now uh, in terms of the relationship that exists between the directors and the company. So we have the company on one hand, and then the directors. Now, in middle of this, the directors owe the duty to the company, and there are several duties that they owe to the company. You have the duties at common law, and you have the duties that are called the fiduciary duties. I've already taken you through the duties of a director. It's also important for us to understand that these directors have been given the management powers. Other than just having the duty, they also have the management powers to manage the company. So the company is going to run through the directors, who are as agents of that particular company and represent the company in all spheres. So the management of a company is done by the directors, and of course led by the managing director, and it's in one group, which is called the board of directors, where all the directors are seated. So all the directors, they may make a decision which is to affect the company itself, but when they're making those decisions, they must put in mind that there is fiduciary duty and also the common law duties, that any decision that they make will not be um, against the interest of the company. So everything they do will be for the success of the company, and anything they do must be promote the business of that particular company, and not their own personal interests. So in between the directors and the company, we also have the shareholders, who we shall look at in our coming lecture series. So those shareholders, they hold the directors accountable. And in case of anything, they can be removed by way of voting to remove the directors. So directors can be removed in a general meeting, where the members of that particular company will vote to remove that director from service. And once the director is removed, there can be a replacement of such a director. And of course, the communication must go to the registrar of companies. Now, the company as it is, on the other hand, it is also it has an obligation towards the director, and one of them is that it has to pay the director for the services, because the director is an employee of the company, and whatever they do, the company has to remunerate the director. There is a way the director's remuneration happens, and some of it may be through uh, through the share price, where we look at how to remunerate the directors based on the share price. We will look at this when we're looking at moving away from the company law to corporate governance. And at that, we will discuss many of the things that the directors can do and what the directors cannot do, and also the position of the company towards the directors. Now, what is the position of a director? We've talked about being a director and all that, but now what's the position of being a director? What does the director come to do, or what does the director do for the company? So the first one is that the directors are agents of the company. So the directors will represent the company, because remember, the company is, although is a person, he is a juridical person. And as a juridical person, they cannot have their own independent voice, but they use the proxies. They use directors as their agents, so they will communicate on behalf of the company. Of course, they will also carry out businesses and make decisions on behalf of the company as their agent. And in this regard, directors are not personally liable for some of the acts they do as an agent of a company, unless they are going beyond their fiduciary duties and violating the articles of association as well, in excess of their powers. But if it's discretionary powers, or a decision which is made on discretionary basis, then by virtue of them being agents of the company, they are not liable for some of those actions. It's also important for us to know that we may have directors as employees of the company. Of course, as I already said in our previous slides, the company has to remunerate directors, and there's a way that remuneration is calculated. So directors are employees of the company, and they can be fired, but the only way they can be fired is not by fellow directors, but by uh, a way of passing through a general meeting, a resolution to remove a director. So the shareholders comes in to hold the directors more accountable, to extend that in case they are not happy with the way the director or the whole board of directors they are conducting their company, they can remove one or even all directors. Then they can replace them with another director. Also, the directors are trustees of the company, and they have to do everything as a trustee. Remember, if you're a trustee of the company, you have to make sure that you are the custodian of that particular company. So they cannot misuse the their position as trustees to maybe use the company asset. Remember, those they will be property owned by the company, but who takes care of those property will be in charge. I mean, directors will be in charge. Okay, so we have come to an end of this particular chapter topic, and I know that we have run through this topic in a way that we only captured the most essential parts, but there are several other areas that you might still go back to read a bit and maybe build on what we have discussed. Otherwise, thank you very much for listening to this lecture series. I hope you have understood the powers of a director, the appointment process of directors, the various stages of appointment, the relationship between director and the company itself, and also you have understood the duties of a director. So next lecture will be lecture 6, which will deal with resolutions of meetings. And that now brings the director and the shareholder together in the general meeting or special meetings that a company may constitute. The resolutions is the outcome of those meetings. So we'll be dealing with this in our next chapter. So thank you very much for this chapter, and see you in our next lecture recording.